Yeah, and I'll say one last thing. We'll take questions at the end of the presentation.
Yes, but if a question comes up, during the process, feel free to go ahead and chat it if it, if it keeps you from losing it by the time we get to the end. Thanks everybody for being here today. I'm going to apologize in advance. We had a little technological snafu, and I haven't been able to share my screen. So Robin has the slides on her end, and I'm going to tell her when to move on to the next slide. And she actually has them in PDF format, not in the presentation format, but I don't think we'll have any trouble with that. Okay, next, please. Starting with introductions, and go on down to the next one.
Sure.
I want to tell you a little bit about myself so you know where I'm coming from. I was an academic librarian for several years in the 90s when the internet was just really, the modern internet anyway, was getting exploding on the scene, and people were kind of going crazy about the kind of legal and policy issues, what you can and can't do, etc. And I just found myself getting interested in that type of issue, ended up going to law school, and I've been practicing law since 2001. And I've had my own practice, digital information law, as you saw on the first screen, since 2010. I've continued to work with libraries throughout all that time, even when I was at firms. And I do a range of things, but my real heart and focus is copyright. So that's perfect for the California Revealed project. And I do work with a lot of libraries, so I just want you to know I'm still in the library world. Next slide, please. So I'm not like some outsider coming in and giving you legal advice. Oh, well, I'm not giving you legal advice. I want to tell you a little bit about these webinars. They are, as Robin mentioned, being recorded for future access. So if you have colleagues that aren't able to attend live, then they can view the recording if they want. I and the rest of our team will be giving you various legal information, and we can answer questions for you, but I need to be clear that we can't give you legal advice. If you need legal advice, you need to ask your own institution's counsel. We'll also be providing you with guides, tools, etc. We are working on a website, and as soon as that's up, Robin will be letting all the participating libraries know. In the meantime, we'll have workarounds. I believe that Robin has already sent you all a couple of things for today's workshop, one being the slides and another being more or less a handout, which I'll talk about. And we are planning on future workshops, on the first on rights statements. And if you don't know what that means, that's okay, because we'll learn. And then we are tentatively planning on having one or more additional workshops to address questions that arise throughout the process as you all get into the project, if that warrants another workshop. Next, please. So let's move on to some copyright questions, and you can just keep going. So does the work qualify? And I mean qualify for including it in the California Revealed project. And when I say work, I mean the one individual item, but in some cases you might be dealing more like with a collection instead of an individual work. So keep that in mind. So to use it in the California Revealed project, the work must be either in the public domain, which means it's not protected by copyright. And I want to explain that term, or spend a minute on that term, because it's misused a lot. It's actually a term of art in the field of copyright, but it is perhaps more commonly used to mean something that's publicly accessible, like anything that's openly available online. When we talk about public domain in the copyright context, where we mean it's not protected by copyright. So I just want to make that clear. So if the work is protected by copyright, your institution needs to have the permission from the copyright owner that's necessary to be able to include it in the California Revealed project. And I'll tell you more about that in a second. Next slide, please. So if it's protected by copyright and you don't have permission to use it for something like this, it cannot be included at this stage, at least. So some people think that if everything that's really old is in the public domain. Well, and copyright does eventually expire, but it lasts a really long time. And the term of protection has changed many times over the years, which adds to the confusion. At this point, some unpublished materials, not all, but some, are still protected by copyright if they're as old as having been created in 1896. So just because it's, quote, old doesn't necessarily mean it's public domain. Next slide. So how do you know whether it's protected by copyright? It depends on a few things. When, or how to answer that question does, when it was created or published, the status of the author or the authorship, and by authorship I mean whether it was created by, whether the author is an individual or whether it was a work made for hire. And the handout that you have talks a little bit more about works made for hire, but I can answer questions about that if you like. And also whether the author is dead or alive. It also depends on what formalities were required at the time the work was created. Under current law, since 1989, a work is automatically protected by copyright without the need to go through any formalities. But at different periods in history, the law required that the work be published with a copyright notice and or that it be registered with a copyright office. So whether an older work is currently protected depends on the laws that were in effect at the time it was created. To figure out, or to help you at least figure out all of this stuff, the copyright term chart, that's sometimes called the Peter Hurdle chart, some of you might be familiar with that name, is the tool that you want to use. Now I've given you the URL, and Robin, if you'll scroll down, we have a couple of, I think 3 slides showing parts of the chart. So this is kind of what the chart looks like. Across the top is the category of the type of work. Never been published, never been registered. And then more specifically in that left column, an unpublished work, this is how long the copyright term lasts. And in the right column, if it's in the public domain, when did that happen? So for the first one, an unpublished work that was never registered, the work will be in the public domain if the author died before 1945. So you see it kind of, and scroll on down, Robin, please. So you see it kind of walks you through this, all these, whoops, oh, go past that slide. That was a mistake slide. I caught that before we got on today, but because I couldn't do it live, you're still seeing it. So then it goes on, works registered or first published in the U.S. Then we've got, again, the categories, more specifically, date of publication, any conditions, like that second column, you'll see it was published without a copyright notice. And then the copyright term, none, it's in the public domain. At one time, if you published a work but did not put a copyright notice on it, it automatically went into the public domain, never protected by copyright. So go on one more slide, please, Robin, and you can just kind of keep scrolling through the next one. Just gives you more about the Peter Hurdle chart. So just to give you an idea of how long it is, because this still isn't all of it. So that's a very, very helpful tool for helping you determine whether something might still be protected by copyright. So let's say it's protected and you have some sort of permission. Do you have the permission that you need to include it in this project? So the permission needs to be, it doesn't have to say, be as specific as saying, yes, you can use it in the California Revealed project, but it does need to be specific enough to be clear that it allows you and us to do what's going to be done with these works, basically, which is to make copies, to display to the public, and distribute to the public. Each one of these is a separate right of a copyright owner. So we need to make sure that each one is addressed in a any kind of permission statement you have, and then that you can do so for free. though you'll get more on this later. It might have been covered yesterday too. It is okay for you to charge cost recovery if necessary for some high versions of high resolution images that users might download, but lower res copies need to be available for end users for free. And then the permission needs to have no restrictions on downstream users or the end user, because we're making these available to the public. Public needs to be able to use them for whatever purpose they want or need to. The permission should be in writing and signed by the copyright owner or the owner's agent. And I have beneath that, who may or may not be the one who gave you the work. So the reason one reason I go through so much detail on this is that, especially for for special collection type collections, a lot of libraries and archives end up with wonderful collections that they've had for many years, with a quote donor form or a gift form that says something very general like, I give this to Santa Fe Springs Public Library, they can do whatever they want with it, and it's signed by the donor. And that's fine, except that the donor may or may not be the copyright owner. So we want to, and do whatever they want is probably not what it says. So if it says something like to be included in the library's collection, public collection, there's some question there about whether they might have intended it to be distributed, copies to be distributed as they are on the internet, or just something that people can walk into the library to consult. You see what I mean? So, this is why I raised so many of these issues. Go on to the next slide, please, Robin. And I know I'm skimming. I'm very lightly touching on these things because this is, I guess I should have started with this, kind of introducing you to these issues, and we will be talking and corresponding with you more on some of these issues. And certainly, as you have questions arise, then you are more than welcome and encouraged to contact us, and we'll try to help you sort them out. So, how do you figure out who the copyright owner is? Sometimes it's obvious, sometimes it's not. In the handout that you've gotten, I've included I called it guidelines here. Really, it's kind of a list of tools to help identify the copyright owner. It will be posted on the California Revealed website once that site is launched. It has, like I said, it has a list of steps and then tools to help you in each step to take if you're having trouble identifying an owner. So if you cannot figure out who the owner is, you probably have an orphan work, and some of you know that term, I'm sure. An orphan work is one that's protected by copyright, but for which you can't either identify the owner, or you can identify a likely owner, but you're not able to locate the owner. So by definition, that means you can't seek permission to use it because you don't know who to get permission from. The law gives no exceptions for orphan works right now, so we are excluding them at this point, at least from the California Revealed project. You may see and hear a lot about people using orphan works in digitization projects, and those who do so are relying on fair use. There's a lot of discussion. There are quite a few guidelines on that topic, but just for our purposes at the moment for California Revealed, we're not relying on fair use for anything because it's such a subjective area, and we may get into that at a later stage, but at least at this beginning point, we're not going to be addressing fair use. Okay, Robin. Anybody has questions about that? Let me know. So in addition to copyright issues, we have some other legal issues that may come up, and I want to just speak generally for a moment about that. When you make actually, I guess I was going to say when you make a legal decision, really what you're doing is you're managing risk. It's about managing risk. But I guess actually most decisions you make in life, or many, are about managing risk, aren't they? So you need to take into account not just your legal assessment of the situation, but practical considerations, or at least sometimes you do. So this is why I have the scale here and the two different things on the side, to each side. A legal assessment can be subjective, and sometimes you might have some degree of uncertainty. So let's say for a particular work or collection, you're almost sure it's in the public domain, but for some reason you have a little bit of doubt. So your legal assessment of pretty sure but we've got a little bit of doubt is really a risk assessment. We have not a lot of risk because we're pretty sure, but there may be a little risk of that we're infringing copyright if we do this. So then on the practical side, you add to that, just forget about the law, whether it's technically legal or not. Is anybody going to care if we make this publicly accessible? And if they do, what's the most likely thing that's going to happen? Will it be that we get a notice or a request to remove it from the site and that's fine? Then, very minimal risk there, right? So scroll on down just a little bit for the rest of the slide, Robin. So really a lot of what we'll be working with you on from the legal perspective is not just understanding and applying the law, but reducing risk. So if you think of it as not only what's right and what's wrong, but reducing risk or managing risk, that's a good mind frame to be on. Okay, next slide. I have a good example for you. Privacy law is a great example because U.S. privacy law is a lot more limited than most people think. Most of you probably think you have more rights under privacy law than you actually have, which means that expectations are greater than actual rights, right? A few specific laws might apply to some of the materials that you have that you want to include in this project, like HIPAA, which is the Health Information Portability and Accountability Act, so that's about health information, or FERPA, Educational Rights, or Records, excuse me, Educational Records Privacy Act. But most U.S. privacy law is very specific like that. We don't have really one broad general law. So other than those few specifics, your only concern is violating someone's, quote, reasonable expectation of privacy. So right off the bat there, you're starting off with subjectivity, right? So scroll on down a little bit, Robin, to the next slide. In addition to that, you want to keep in mind you've got your practical considerations. The law, I said may, but it does allow one to make available information that some people would prefer to remain private. So this may be a practical consideration. Even if you have the legal right to do it, do you want to do it? So in this context, we might be talking about something like personal correspondence or journal or a diary. If you have materials that fit into this category that you're concerned about, you might consider, if you want to include them, trying to get or checking to see if you have a release from the subjects that you're concerned might be unhappy with your making this information public. Okay, next slide. So still in this context of risk management and reducing risk, we, the California Revealed team, will be working on policies and procedures to address any claims of violations that might come through. So be it a copyright owner or a privacy issue or something else. We haven't got into that yet in any detail, but we will be working on that, and of course you'll all know about it when we finalize it, or maybe before in the process. And certainly you'll have the opportunity to ask any questions. We might end up including that in a future workshop webinar. Next slide. So that's what I have for you today. I wanted to give you the basics, and I wanted to have a lot of time for Q&A. So we've got about half our time left for questions and answers. Anybody have any questions, or is there anything you would like to go back to and go through in more detail, given how, not how quickly we went through it, but just how kind of surface level things have been so far? If anybody felt totally lost at some point, let me know, and I can go back and explain things to you. So, questions coming in. Does Jace asked, does pre-1923 apply to photographs? Yes. So the dates, you'll see when you look at that, I call it the hurdle chart just because it's a nice nickname. It's a lot shorter than the long title. When you look at the hurdle chart, you'll see at the very bottom there's a category for sound recordings, and that's because sound recordings have their own bizarre history and status in copyright law. Otherwise, everything that's protected by copyright is treated the same as for most purposes, including as far as how long protection lasts. So if a photograph's protected by copyright, then whatever term applies to it, given the situation, as we looked at on the hurdle chart, will be true for that. And just by the way, the copyright owner in a photograph is going to be who? Not the person depicted in the photograph, but the person who took the photograph, right? Because the creator is the copyright owner. Nancy asked, do local governmental records require a release? Probably not. Local records, so federal governmental documents that are created by the government, and the government outsources creation of some materials, right? Documents that are created by the federal government are not protected at all by copyright, but this is not necessarily true for state or local governments. So the state and local governments have their own open records types of acts, and they so citizens, for the purpose of being transparency. So for what we're doing here with California Revealed, at least for most of history, I guess I can say, there shouldn't be a need for a release for local government records. But that's actually a topic that we'll get into more as we get more deeply into the project, because there are quirky exceptions here and there. Oh, that's a good one. So waiting for name asked, do I have any particular guidance on oral history recording? Excuse me. So oral history, I think, is a good example of one of those kind of murky areas, kind of like the examples I gave you in privacy. So if there is any copyright protection in an oral history recording, then it's going to belong to whoever made the recording. But of course, the content is what you're going to be most concerned about. So from a legal perspective, you would have the right to transcribe or post the sound recording of an oral history recording that you have, assuming that you made the recording, or the person who made the recording for you gave you the permission to do that from a copyright perspective. So what you're really concerned about is more along the lines of privacy. Is there any reason why the person giving the history, or perhaps someone they're discussing, would not want to have that posted, made publicly available? And this is probably not a legal issue so much as a practical matter. Do you have any follow-up questions on that? Because we can get more into that if you'd like. Next question, If a county entity commissioned a photographer to take photographs and paid for those photographs, do the photographs belong to the county? No. So this is a wonderful question and very popular area or common area of misunderstanding. When you, so a work made for hire is a work where the hiring party is deemed to be the author of the work and therefore the copyright owner. There are two categories of works made for hire, and this is outlined in the handout that you have, if you want to go back and refer to that. But the two categories are a work created by an employee. So if you as an employee create a work that's part of your duty as an employee, the copyright in that work is deemed to belong to your employer, who's actually the author of the work. So if you see on the Peter Hurdle chart, work made for hire, that's what we're talking about. The second category of work made for hire is a work that's created by an independent contractor. And this is where it gets really squirrely, because the copyright in an independent contractor, well, sorry, forget about the copyright. A work created by an independent contractor is a work made for hire only if it falls into one of these 9 kind of weird categories that are in the Copyright Act, and they include things like atlas, textbooks, like educational text, audiovisual works, and again, that list is also on that handout. And if one of those weird categories, and which photograph is not one, and the two parties have signed an agreement stating that they both intend for the work to be a work made for hire. Otherwise, it doesn't matter how much money you pay to, in this case, the photographer, to take the pictures, that person is going to own the copyright unless you have an agreement to the contrary, unless they assign it to you. If you, for purposes of this project, if you don't have an assignment of copyright, you might have a license. If there's a written agreement between the county and the photographer, you want to take a look at that for sure, because it might tell you what you can and can't do, and if it doesn't allow you to give you the permissions you would need to include in this project, then you would need to go back and get that. Next question: how would old school letters from 1931 to the 1950s be classified? Some are thank you letters sent to the librarians for school visit. Are these property of the library's librarian, or would they be considered orphan works? Well, they're physical property of the library, but the copyright does not belong to the library. The copyright, and that's a great example of the kind of work that can be troublesome, and yet they're not orphan work. The copyright would belong to the writer of the letter, because they're the creator. Copyright always belongs to the creator, from at least as a default, unless it's work made for hire. So it's not an orphan work, because unless any of them are anonymous, you know who wrote it, right? So it might not be an orphan. It might be an orphan now, because you might not be able to contact that person, because copyrights last longer than our lifespans do. When someone dies, if they don't otherwise address it in their will, their copyright and anything they have descends to their descendants. So if Mrs. Smith wrote a letter in 1931 and it's now passed, then her children would own the copyright in that letter. So you would want to write to them and ask them if it's okay to include the letter in this project. Next, and if anybody has follow-ups to any of this, please go ahead. I would really like more information on local government records. It seems that local governments have their own interpretation on public access. Okay, let's, excuse me just a second. Let's think about, Robin and I and the rest of the team will talk about how to, what to do about that. Maybe we'll have another webinar Maybe we can put together some sort of guide, but we'll do something about government records, local government records for you. Because I'm sure several of you have those. Okay, could you talk a little more about the copyright status for personal correspondence during the mid-20th century? Could it be considered published, depending on copyright law at the time? It could. Tell me, Kelly, what context you have in mind when you ask, could it be considered published? What's been done with it that makes you think perhaps it would be considered published? So we can use that as kind of a starting point. Next, while you're typing, I'll go to the next question. How can you prove or make sure a work is unpublished? Well, that's a good question. The orphan work, of course, the whole point of an orphan work is you're trying to prove a negative. You're trying to prove that you don't know something. But I hadn't actually thought about how you can prove a work is unpublished. Because that's also basically proving a negative. If you have reason to think it might be published, then yeah, that's the thing. I think most people just don't really, I think that situation probably doesn't come up much. But this, golly, if for our purposes, Robin, that would kind of fall in the category of orphan works if we're not sure about that and if it matters on the copyright term. If it doesn't matter for the copyright term, you know, if it's going to be protected whether it was published or not, or if it's going to be in the public domain whether it was published or not, then at least for our purposes, we don't have to worry about it. But I assume you're asking because you're not sure, and so that would lead back to, you know, not knowing whether it's protected by copyright. Is that is that pretty much what you have in mind, Susan? Is that why you're asking, I assume? Because, you know, there's no way to prove that it hasn't been published. I think all you can do is do your research. But ultimately, if you have reason to think that it's been published, you know, if you have a suspicion, then that might be something that we should consider. We'll have to think about that, I think, and maybe follow up with Susan on that. So let's see. And Kelly hasn't given me more about her question, so I'll keep going down the list. Okay. Nance says this is off topic, and it's really not. But who has the copyright on school yearbook pictures? This isn't off topic at all, because this is actually a common issue with, as you can imagine, you know, with the internet. So it's probably going to be the publisher of the yearbook, just because of contracts. So the original copyright owner would be the photographer, the one who took the photograph. But probably the contract between the photographer and the publisher would assign the copyright to the publisher. If I'm assuming, actually, let me back off. I'm assuming that that's the kind of situation where, you know, you've got picture day at school and the publisher comes to school and kids march through and get their photos taken. In the case of something like, at least in Texas, you know, seniors get their big senior photo portfolio done, you know, and they go to private photographers and then submit one of those to the school yearbook. So then it would be the individual photographers. So I think the starting point would be to go to the publisher of the yearbook and see what they say about their ownership of the copyright. Let's see. Next, hang on, my window is dropped down. Personal effects such as wills, letters, report cards, etc. What if a descendant comes forward and says they want it back? For example, my grandfather never would have given that to you. I want it. So physically want to take it back. If you don't have any kind of a donor agreement, or, you know, if you don't have any kind of evidence that they've given it to you, then from a legal perspective, then you can't prove that you have the right to be in possession of it. And then from the practical perspective, you might want to think about how to handle it just from a practical perspective. Even if you do have an agreement, if the defendant says, well, he never would have signed that, he must have been out of his mind or under duress or whatever, then you've got that practical consideration. Do you want to treat this guy like he's a little out of his mind, or do you want to play nice? So that's, and you're talking about just physically trying to take something back, right? As opposed to you posted something online and now the defendant wants you to take it down, which would be similar but a little bit more to it. Nancy asked, does HIPAA apply to people who died before the law was enacted? It applies, I'm going to double check on that, but I'm pretty sure it applies only to records that were created as of the enactment date. But let me double check on that. I'm making myself a note here. I'll double check on that and get back to you. And does anybody have material that you might include in California Revealed that you're concerned might have HIPAA might have implications for? Do we need to get further into HIPAA at some point, is what I'm trying to ask. Need more information on HIPAA, which again is the Health Information Privacy Act.
We can ask that offline and ask folks to respond to that.
Okay. So somebody says, if something was created before 1989 and has no copyright listed, it has no copyright notice on it, I think is what she means. If it's published without a copyright notice, then it's going to be in the public domain. But if it's unpublished, then it's going to be, well, depending on when it was created, it's likely protected. But up until, well, actually, I take it back. It's not 89. This is what's so complicated. The law changed so many times. It's actually until the current Copyright Act came in effect, 1977, that publication without a notice meant the work goes directly into the public domain. And then in 1989, the last formalities, registration, were abolished. So there's this 12-year period there where it was kind of a weird, Congress, didn't know what to do when they had to pass this law in 1989 in order to comply with an international treaty. So the short end of the story is if it was published between 78 and March of 1989 without a copyright notice, if it was registered within 5 years of publication, then it's going to be protected by copyright. But that's just the 78 to 89. Pre-78, if it was published without a notice, it's public domain. And I know that sounds very confusing because it is, but tell me if you need more clarification on that. So, question about registration, the requirement for registration with the Copyright Office, excuse me. Is everything created now protected by copyright with no further action by the creator necessary? Or it is, but it's my understanding that this has not always been the case. Right, and that's why this chart is so helpful, because up until 1989, a work had to be registered, to be protected by copyright. But then when the law changed, rights were retroactively, for a published work, had to be registered. Rights were retroactively given to some works, like unpublished works, and it's really kind of a convoluted situation. But it is true that up until 1989, a published work at least had to be registered to be protected by copyright, which again is why that chart is so invaluable to help you figure out whether a work is protected. And there are probably 40 or 50 different lines of categories in there, and each one has a different method of determining protection. Next question is, during the 1930s, as part of the WPA, writers and researchers were commissioned to research and write about local history for the benefit of particular counties. Who is the copyright holder of these documents? Excuse me. Portions of them were included later in some state histories published by the WPA. I'm asking because many of the original documents compiled by various writers and researchers for the counties of Marin and Sonoma have ended up in our library. Apparently, the county librarian at the time supervised this project. So, I love that kind of material. There are a few layers here, right? They were commissioned, okay. One is that the definition of a work made for hire under the law at the time is a little bit different than it is now. And had, I'm trying to remember the language, but it did not require a specific contract like it does now. It had something to do with the intention, the clear intention of the parties. And I'm going to look that up and I will get back to you. Let me make myself a note for that. Pre-77 work made for hire. So it may be, it's possible that the works, the letters, the original, or not letters, but the original writings were works made for hire belonging to the federal government. It's also possible that the writers assigned, and as part of their deal with the government, assigned the copyright to the federal government. The government can hold copyright. So if the author in this case, what would have been, it is not a work made for hire, and the author, the researcher, would have owned the copyright, but assigned it to the federal government, just because it belongs to the federal government doesn't mean the copyright goes away. If the government creates something directly, a government employee creates something, it's public domain. But the government can be the recipient of an assigned copyright, and the copyright continues. It's also, there could be, you know, other, oh, I know what I was going to say. You said some of them had been published by the WPA. So if they're published by the WPA, then that that implies at least that there should have been, I won't say, it doesn't imply that there were agreements, written agreements, but there should have been some sort of agreement, contracts with the writers. So I am going to look into that definition of work made for hire for you. But it may be that the answer is it depends on what kind of agreement the party executed at the time, which may be something that you could find relatively easily. It may not be. And you also, if you haven't looked, maybe you have, but if you haven't looked, for those, I know I realize you have the originals, but for those that have been published as a collection, look at the copyright notice in those, I assume they're books, in the publication, and see what it says about the copyright. And what you want to look for is not just the general copyright, you know, 1939 U.S. government, or well, I guess it wouldn't be the government because there wouldn't be a copyright. But look for whatever copyright information is in the front of the book, because it may say something like, these copyright in the documents belong to the remain with the original author, or, you know, published with permission, or something like that. If it says something like published with permission, then you know the author, the actual person who wrote it, owns the copyright. So take a look at those publications and see if that provides you any help. I hope that helps, but I will get back to you about the older work made for hire definition. And let's see. Next question. So something like personal correspondence that was just sent and not published is still protected by copyright So it was written and sent during a time when published works had to be registered with the Copyright Office to be protected. Yeah, that's one of those weird retroactive things. Unpublished works, so let's see, if this is a letter, then it's not anonymous, right? So an unpublished work where we know who the author is has a term of life plus 70, which is the current copyright term. So works from, if it was, if the author died, if the author died before 1940 something, then those 43, I think it was 1945, then those works will be in the public domain. Otherwise, they're still protected. This is the crazy thing about copyright law right now. Mm-hmm. I could get on a soapbox, but I'm not going to do that right now. The last question at the moment. Our oral history cassettes were created by 3 organizations: Friends of the Library, Local Historical Society, and the local American River College, Los Rios, back in the 70s and 80s. The participants signed release forms. They are to be used for research and can be reproduced, copied, exhibited, or distributed for historical purposes. So does the library have any rights to them? That depends. I'm sorry to sound like a lawyer, but I tell people, if you go to a party where you don't know anybody and you want them all to think you're a lawyer, anytime somebody asks you a question, just say, that depends. You know, if they ask you what the weather is, say, that depends. So I'm sorry to do this, but that depends on what, in part, what that release says, and also on any agreements. Let me just say, on any written agreements that are involved in this situation, whoever it might be between. So I really, it's not clear what right. It doesn't sound like the library would own a copyright, but it's not clear what rights the library has, and that could get kind of complicated, because while you can have those 3 organizations grant a license or even assign the copyright to the library, that's going to cover the copyright portion of it. But since the people speaking engaged in this project under the understanding that these items would only be used for research and historical purposes, there's that limit colors everything else that flows from that, if you see what I mean. But it really, that's the kind of thing where, you know, you would want to take a close look at the language, and if you can, maybe have your institution's legal counsel review it and tell you what they think. Okay, next. So regarding personal correspondence or photographs or anything else, what constitutes publishing? Okay, so the current Copyright Act has a very clear definition of publishing, and it's either offering to distribute copies to the public or actually distributing copies to the public. Before 1977, under the earlier Copyright Act, the statute itself didn't have a definition, so the law was really from case law, which just means it's not 100% clear, but it's roughly the same idea. If something has been distributed, and I can look up that language as well and be more specific on that if you need me to. If something has been distributed to the public, or if there has been, I think the 1909 Act didn't have, it was a little bit more limited in the offer of distribution. If copies have been made and distributed to the public, it's probably been considered published. But assuming it was created before 1978, then it might be a little bit less simple than that. So I'm making myself to get back to y'all on this as well. Next, if the local club of the League of Women Voters is no longer in existence, does a work created by them constitute an orphan work, or can permission be sought from the last officer, or can one receive permission from the national organization? That is a perfect, that's like a law school orphan works question. when a copyright is owned by an institution of some sort, and the institution goes away, what happens with that copyright depends on the facts of the situation. So in this case, I don't know what the relationship is between local league clubs and the national club. It may be that even if there was no, and I don't know what kind of dissolution agreement or requirements or whatever they have, it may be that the national club automatically gets everything left from the local club. If not, if they just kind of disappeared, then it's an orphan work, but it's the weirdest type of orphan work to me, because there is a copyright, but there's no copyright owner, really. So the first thing to look into is the possibility that the national organization took possession either kind of automatically through their their bylaws, rules and regulations, etc., or through some sort of dissolution process or agreement with the local clubs. So that's the first thing to look into. After that, it's an orphan, so there's not, if the national group doesn't own it, then there's not really an owner. It would be a showing of good faith and trying to play nice to get the consent of someone like a last officer at the local club. For purposes of California Revealed, if it's an orphan, then it's not going to be included. Oral history question: are volunteers treated or viewed the same as a government employee? Many recordings were created by library volunteers, so would the recording fall into the public domain? So when you ask would it fall into the public domain, why do you ask that? Is that, I mean, are you at a federal institution? Because it's only works that are created by the federal government that automatically go into the public domain. So if you're at a local institution, local government, copyright still applies, and the volunteer would not be treated the same as an employee for the purpose of a work made for hire. So with these oral histories, there's also a bigger question, and this might be something to come back to at a later date, especially if there are a lot of oral histories in the project. There's a question of whether there is a copyright, really, because in some cases at least, for something to be protectable by copyright, you don't have to follow any requirements, but we still have a few follow any formalities, but we still have a few minimal requirements for something to be protectable. It has to, the one I'm concerned with here is that it has to have, quote, a modicum of creativity, meaning that the person creating it contributed something, I say, out of their little brain. They didn't just spew a fact or press a record button. They did something else. And so when someone records, a movie or a music video, actually, an audio visual, almost any audio visual is a little bit more straightforward, or a creative sound recording is more straightforward because you make a lot of choices as to sound, lighting, appearance, filters, all sorts of things. When you're recording an oral history, you may not. It may be just, here's a tape recorder or a computer. You turn on the microphone and you're done. So So that can be an issue, and we'll follow up with more on that oral history issue.
We've got 2 more minutes here for our recorded time.
We've got 2 more questions, and let's see, is this an update? Oh, clarification on the League of Women Voters question. Document is a transcript of a meeting they conducted, so there are no individual speakers. Okay. I would go through the same thing I said before. Check and see if you can tell if the national office automatic or somehow might have possession, and then just kind of go from there. I can stay on the line for as long as people have questions, but if you need to sign off, then go ahead. 2 other questions. If letters are donated by someone other than the author, is a signed release form of any value? That's exactly what I was talking about when I mentioned donor or gift forms earlier. The person giving it to you, donating it to you, is not the copyright owner. So from the copyright perspective, no, that doesn't have any value. And assuming that the author didn't, assign the copyright to them. If they are the descendant and maybe they inherited the copyright when the author died, then you'd be good. But if they're not the copyright owner, then no. So the local AAUW group taped public meetings relating to water issues in 1978. Copies were given to the library for public use. Do they have a copyright? With the caveat that of everything I just said about recording things like oral history, and recording a meeting would be very similar. It may not, just because it might not rise to the level of having a modicum of creativity and be protectable by copyright at all. And again, we'll come back with more information about that. Next, how does the law determine who inherits the copyright when someone dies? Excuse me. That doesn't have anything to do with copyright law. It has to do with wills and estate law. So if a will leaves everything to my loving spouse, then the spouse gets everything, including the copyrights, any intellectual property. A will can specifically assign a copyright or anything else to an individual person. If someone dies intestate, then you follow the law of the state as to what happens with the possessions of that person, but it's treated like any other possession when someone dies. Either it descends via a will or it descends via state law if the person doesn't have a will. That's the end of the questions that I see on my screen. Does anybody have any closing questions? As things arise, as you go through the project, just remember that part of what this team is here for is to help make this project successful for everybody. So send along your questions, and I'm pretty sure based on all these questions, we'll end up having at least a couple more workshops on these types of issues. So we'll keep you posted on that as well. Thank you all so much for being here, and thank you for asking such wonderful questions.
Well, we'll have
do I have a recommended book? Excuse me, Robin, let me just respond real quickly.
Sorry.
There are quite a few. I did not include this in the handout because I was just giving you things directly related to what we did here today. But I can recommend quite a few resources on this whole big area. So I'll put together some sort of list that will end up on the website that Robin's working on. Okay, thank you, Robin.
Super. Oh, thank you, Gretchen, very much, and thanks everyone for participating. We'll have a listserv soon as well, and that would be a good place to send sort of general questions that might be interesting to all to see. And this workshop has been recorded today. I have recorded every question that was asked, and we'll post those as well. And I think if Gretchen concurs, we could we could transcribe your answers and make that a part of the of what's made available to folks as well.
Sure.
But
yeah.
But thank you all very much for participating. And as Gretchen said, we will have further webinars like this in the future addressing specific issues. Thanks so much, everyone.
Have a good weekend, everybody.
Bye-bye.